Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. You know, you've heard us talk about this before on the channel. As a trial lawyer, what we really like when we go to court is we like judges that are predictable. We like prosecuting attorneys that are predictable. Even if they're predictably bad, as long as they're consistent, predictability is key. Well, I want to talk to you yet again about a very bipolar, very schizophrenic Department of Justice. Yes, they claim to be the most pro-2A Department of Justice in the history of the country, which may actually be the case, but that in many ways is like being the smartest kid on the short bus or, you know, the tallest munchkin. It's comparatively speaking here. And every time the Department of Justice seems to do something where we're all like, yeah, okay, here we go, they turn around and they shoot themselves in the foot, and they have done exactly that again. So today, let's get you all educated and let's talk about how DOJ just veered way off course. Okay, America, we have talked about this case a couple of times before, and we're going to have to talk about it again. What am I talking about? I'm talking about the case of Firearms Policy Coalition v. Bondi, a now successful challenge to 18 United States Code Section 930 sub A, a case that was filed and successfully litigated in the Northern District of Texas. What we're going to focus on today is the remedies, because the injunctive relief that the court issued apparently is, well, too good for the plaintiffs here, and the United States Department of Justice has a real beef with that. In their opening memorandum as to why the remedies on this case should be significantly limited, and what I mean by that is limit the number of people who will actually benefit from this ruling. In fact, try to shrink that class of individuals down to as small a group as humanly possible. And I want to ask the Department of Justice this question. If the application of this law is unconstitutional to everybody who was named in the complaint, how is it not unconstitutional to everybody else that would be in the same situation? But the United States Department of Justice opens it up this way. Moreover, this court should clarify that its permanent relief applies only to those, whether identified or not, who were members of the organizational plaintiffs when the operative complaint was filed. This limitation is necessary because the organizational plaintiffs did not have standing to represent and obtain relief for members who did not yet exist, and because equity should not incentivize retroactive free riding. Had plaintiffs sought to secure relief broader in scope, then they could have sought to certify a class action. However, having declined to do so, plaintiffs are limited to securing relief for the members they were empowered to represent when they filed suit. And so in the interest of judicial efficiency, even though this law has been found unconstitutional for dozens and dozens and dozens of people, the United States Department of Justice would like to limit that remedy to just those people, and then we can have another lawsuit about the same issue where we can then certify a class and try to get relief for the entire nation. Now, you guys might remember this video we did right here, where allegedly the United States Department of Justice had asked for membership information from both Firearms Policy Coalition and the Second Amendment Foundation, who are both parties to the suit, which means we got links for them down below. The Department of Justice and the court ultimately backed off on that. However, in this new memorandum, there's a real question we have to ask ourselves now, which is, did the Department of Justice really back off on it? Because this is how they pled it. Shortly after the court entered final judgment, defendant's counsel contacted plaintiff's counsel. In that communication, defendant asked whether Firearms Policy Coalition, Inc. and Second Amendment Foundation would provide defendant with a verified list of their members as of the date of the complaint so that the federal government could identify the beneficiaries of the injunction and fully comply with the court's final judgment. Defendant also informed plaintiffs that it would agree to a protective order that would limit the use of membership information to compliance with the final judgment. Yeah, and I have no doubt that the Department of Justice made that request. What do you suppose FPC and SAF's response was? Plaintiffs declined to provide membership information and further took the position that the judgment is not limited to members at the time the complaint was filed. In plaintiff's view, membership information is not necessary for the government to comply with the injunction because members can identify themselves as such if questioned about carrying a firearm in a post office. Now, as I mentioned previously, the entire purpose of what the United States Department of Justice is doing here is to limit to the fewest number of people humanly possible those who benefit from this court's ruling. And as the Department of Justice puts it, The declaratory judgment and permanent injunction should be limited to the two individual plaintiffs and to any identified and verified members of the organizational plaintiffs when suit was filed. Well, if FPC and SAF are not willing to turn over their data, which we completely understand why they'd not be willing to do that, therefore none of them have been verified, then apparently this lawsuit is only going to benefit the two named plaintiffs. Well, DOJ puts in their memorandum, defendant asks that this court clarify or modify its declaratory judgment and permanent injunction to apply only to the individual plaintiffs and to individuals who A, have been identified and verified as members of the organizational plaintiffs, and B, were members of the organizational plaintiffs when suit was filed. A final judgment with these limitations would be consistent with the specificity requirements of Rule 65D, with the standing requirements of Article 3, and with the principles of equity. Conversely, absent these limitations, the injunction would be untenably vague and would erect enormous hurdles to compliance. So, in some ways, they're kind of holding this judgment hostage, aren't they? They're saying that, other than the two actual named plaintiffs, anybody who's a member of one of these organizations that wants to have the same equitable relief here is not going to do so unless the organization that you belong to is willing to sell your identity out. That is literally the argument that the United States Department of Justice is making. And they make this because they claim that it's the only way that the United States government can ensure that they comply with the court's orders. In a similar vein, an injunction is unenforceable when compliance with it is factually impossible. Here, the result of any injunction that would apply to a host of individuals unknown to defendant would make compliance with such injunction a practical impossibility. Now, what the plaintiffs are saying here is, hey, listen, we're not going to turn over any of the data. It's none of your business, and we applaud them for that. What they're also saying is, hey, listen, if we have a protected person, a person who has enjoined the remedy from this case, who goes into a post office and is now questioned by post office officials, they can always identify themselves at that time as being a member of the organization. That's not sufficient to the United States Department of Justice because they are arguing, plaintiffs argue that the court need not limit its judgment to disclosed and verified members because members can identify themselves as such if questioned about carrying a firearm in a post office. But that would not work. First, plaintiff's position would make defendants' compliance wholly contingent on the acts of third parties who have no legal obligation to disclose their membership affiliation. I want you to remember that. They're under no legal obligation to disclose their membership affiliation, and yet the United States Department of Justice is asking to have the membership affiliation disclosed. Interesting. They also claim this kind of arrangement would place the federal government at constant risk of contempt because it could inadvertently enforce the challenge law against the person who happens to be an unknown member of one of the organizational plaintiffs. The fatal problem with such an injunction is that on the record before this court, it is unknown and unknowable which persons are members of the organizational plaintiffs, information necessary for the defendant to know how to avoid contempt of court. Yes, it's all about making sure that the United States government is not accidentally engaging in contemptuous behavior. I'm sure that's exactly the reason. Except for then, as we get to the very end of the Department of Justice's memorandum, the veil comes off and they really expose what this is truly about. And as we said before, what this is all about, and it's only about one thing, is how can we limit the relief granted by the court to the fewest number of Americans humanly possible. This is what DOJ has put in their memorandum. To conform with Article 3 and principles of equity, this court should clarify that its judgment is limited to members of the organizational plaintiffs when suit was filed. Regardless of how the court resolves this issue of unidentified members, both Article 3 and equitable principles require that the judgment be limited to individuals who were members of one of the organizational plaintiffs at the time this suit was filed. Okay, so what was once a fantastic and glorious victory has now been turned into an absolutely gut-wrenching exercise where the United States Department of Justice, the most pro-Second Amendment Department of Justice in the history of our country, is doing everything humanly possible to make sure as many Americans as legally possible do not benefit from the court's ruling. The case, once again, is Firearms Policy Coalition et al. V. Bondi, brought to us by our good friends at FPC and SAF, which means we got links in the description box for you guys to show them some love. We'll go ahead and link up the United States Department of Justice's memorandum that was the subject of this video down below as well, so you don't have to take our word for it. You can geek out on it for yourself. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, cool. Click on that link right there. Tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.